months, he submits that there is inordinate delay in trial. He prays for bail. Learn a lawyer for the state contents. Petitioner is a resident of Bihar and there is possibility of abscondence. We have considered the materials on record, though petitioner is in custody for more than 3 years, 4 months. Only one witness has been examined. But prosecution proposes to examine
My lord, as many as 8 witnesses.
and there is no possibility of trial concluding in near future. Under such circumstances, we are of the opinion petitioner has been able to make out a case for breach of trial, for bail on the ground of inordinate delay in trial, so and so allowed on conditions. Shall remain within the municipal limits of Kolkata and provide the address where he is residing to the investigating agency and the court below.
And 29 of Narcotic Drugs and Psychotropic Substance Act. Petitioner is in custody for 768 days, that is 2 years, 1 month, 7 days.
What
Initial
is the progress in the matter?
Out of 9 witnesses.
out of 9 days,
January is the next schedule, my lord. 15,
The
16,
petitioner is in custody for 1 year,
So, lawsuit, I'm paying for the expeditious trial. In
2 year, 1 month. He contends there is delay in trial. He prays for bail and a lawyer for the state opposite the bail prayer. Statement of witness and contemporaneous document that is Caesar memorandum disclosed recovery of 5.2 kgs of codeine phosphate from the petitioner. Trial is in progress. 2 witnesses have already been examined. According under such circumstances and in view of statutory restriction at 37 of NDPS Act, we are not inclined to grant bail. We request the trial court to conclude the trial as expeditiously as possible, preferably within 1 year from the next date fixed for recording evidence without granting unbail.
3 witnesses examined, my lord.
3 witnesses exempt. Next.
I am appearing for the petitioner, my lord. I am renewing my prayer for bail, my lord. This case involves the recovery of the commercial quantity of narcotics. Only 3 witnesses out of 13 examined till date. I am in custody for 3 years, 3 months. 2 co-accused persons have been granted bail by this Honorable High Court, my lord. The first order is at page 1213. The second order.
It was rejected on 27th of July. There is an order to conclude trial. We have considered the materials on record. Bail prayer of the petitioner was rejected. Petitioner contents he is in custody for
3 years, 3 months, 19 days.
for more than 3 years and 3 months. Co-accused or on bail, he renews his bail prayer. And a lawyer for the state opposite the bail prayer. We have considered the materials on record. Petitioner is in custody for more than 3 years. There is no possibility of trial concluding in near future. Co-accused have been enlarged on bail. Under such circumstances, we are inclined to extend the same privilege to the petitioner. Also, Dasho. Yes.
The petitioner is in custody for 4 years, 11 months, 12 days.
1800 liters of codeine.
So what?
But-
5 years is in
But kindly
custody.
considers one thing is a resident of Uttar Pradesh.
All right. Petitioner is in custody for about 5 years. He submits there is inordinate delay in trial. He prays for bail and a lawyer for the state contents 14 liters.
But at 1800 liters.
1800 liters of codeine phosphate was recovered from the petitioner. He is a resident of a different state and may abscond. We have considered the materials on record, though allegations against the petitioner are grave and would attract the statutory restrictions under 37 in the matter of bail. We note petitioner has languished in jail for about 5 years. There is no possibility of trial concluding in near future. Delay in the matter cannot be attributed to the petitioner. Under such circumstances, we have been able to, petitioner has been able to make out a case. So and so allowed on conditions. Petitioner while on bail shall remain within municipal limits of Kolkata. Again, condition shall meet officer in charge STF police station once in a week until further.
Most of them.
Next.
Lord, I am for the petitioner. Lord, I am the son. Recovery from my father, he is on statutory bail. Well, 15
You are
kindly.
son, father, family business.
Both of
No.
them were there.
Ah,
But recovery from
how
father,
long are you in custody?
85 days.
Lord,
my lord.
after warrant of proclamation and attachment,
My lord, father has been granted bail.
statutory bail of
Statutory bail.
So after how many days?
My lord,
180 days at least.
at least.
So if father is in 180 days on parity for 80 days, huh?
My lord, no recovery from me.
Inheritance is reducing.
My lord, no recovery, my lord.
proclamation and attachment order
And
was passed.
you ran away. No care for your father. Old man in-house arrested. You are running away.
No, they were both of them were there. He managed to flee.
This is not, we can't give you parity. Petitioner is in custody for 81 days. He contends co-accused, who is his father, is on statutory bail. He prays for bail. Learn a lawyer for the state submit petitioner and co-accused were dealing in narcotics. Petitioner had absconded and processes were issued against petitioner had absconded. Full stop. We have considered the materials on record. There are materials showing petitioner and co-accused were dealing in narcotics. Stop.
Narcotics and as well as cattle, my lord.
Narcotics as well were illegally smuggling narcotics and cattle across international border. In view of the petitioner had absconded for a protracted period of time. He co-accused has been released on statutory bail. Under such circumstances, he cannot claim parity with the said co-accused. In view of the aforesaid and statutory restriction of 37 of NDPS Act, we are not inclined to be rejected. Next.
For the petitioner, madam, from the bush of a tree, some contraband articles was recovered. One person was identified.
Fruit of the tree is contraband. What is the contraband?
417 bottles.
417 bottles of fensitil syrup.
Identified by the stores. This happened in November 2022. I mean, April 2023, he gets caught with exclusive possession 145 bottles. Shown arrested in this case.
So we give him bail in this case. There is no direct evidence in this case. Petitioner is in custody for
107 days.
107 days. He submits no recovery was made from his possession. In this case, he prays for bail. Learned lawyer for the state submit petitioner has criminal antecedents. He was arrested with a large volume of narcotics. He was on the basis of materials transpiring during investigation. He was shown arrested in the case. We have considered the materials on record. Petitioner has criminal antecedents. But in the present, the materials on record in the present case, materials on record collected during investigation in this case, do not show he had conscious possession of the narcotics recovered. Full stop. No other material implicating the petitioner in dealing in narcotics in this case has also transpired during investigation. Under such circumstances, we are of the opinion petitioner has been able to has been able to rebut statutory restriction of 37 of NDPS Act and may be released on bail subject to conditions meet officer in charge.
Charge sheet submit.
Hilly police station once in a week until further.
Great.
That is because of your antecedents, sir.
My lord, I am for the petition. The name of the petitioner came from the co-accused statement, my lord. I am in
It's
custody.
Sudro, foreigner. You are a foreigner.
No, my lord, I am not a foreigner.
And in August, we had rejected Rule Amin and others. Yes.
Nothing has been seized from the petitioner.
Rule Amin and others were rejected. Huh?
That is antecedent.
There is a statement of the head constable
Head constable statement is there, my lord.
naming them.
Naming them, and he is named in the FIR also.
Then petitioner submits no narcotics was recovered from his possession. He prays for bail. And a lawyer for the state opposes the bail prayer. We have considered the materials on record. The statement of head constable of BSF and other materials disclose involvement of the petitioner in smuggling narcotics in trafficking narcotics. Bail prayer of co-accused was turned down in August 2023 under such circumstances and in view of statutory restriction and 37 of NDPS Act, we are not inclined to grant bail. Next.
In my lord, I am for the petitioner. 2.68 kg of opium was recovered. My lord, I am in custody for 1 year, 8 months, and 23 days.
Charge
12 witnesses, but no
petitioner is in custody for 1 year, 8 months. He has been falsely implicated. He prays for bail. We have learned a lawyer for the state opposes the bail prayer. We have considered the materials on record, statement of witnesses and contemporaneous document that the
recovery was for this.
Caesar memorandum show recovery of 2.68
Opium.
0 kgs of opium from the petitioner. 2.680 kgs of opium from the petitioner. Under such circumstances, a charge has been framed
Evidence is from my lord, 10th
and date has
January.
been fixed for recording evidence. Under such circumstances, we are of the and in view of statutory restriction under 37 of NDPS Act, we are of the opinion petitioner is not entitled to bail either on merits or on the ground of delay in trial. We request the trial court to conduct the trial with utmost expedition and conclude the same at an early date. Next.
My lord, I am for the petition amended allegation under section 21C of the NDPS Act, Lordship. Lordship, I am in custody for 791 days, 2 years, 2 months, Lordship. Lordship, amongst 11 witness, Lordship, only 5 has been examined, Lordship.
5 have been examined, next date in March. Exclusive possession and
Single accused.
sole
How many days you are in custody?
700
791
That is
days, 2 years, 2 months.
2 years, 2 months.
I am arrested on
Petitioner is in custody for 2 years, 2 months. He submits there is inordinate delay in trial. He prays for bail. Learned lawyer for the state opposes the bail prayer. He contends that trial is in progress.
5 out of 11.
5 witnesses have been examined. We have considered the materials on record.
Exclusive possession 115 bottles.
115 bottles of fencetrol syrup was recovered from the petitioner. He is in custody for more than 2 years and only 5 witnesses have been examined. There is no possibility of trial concluding in near future. Delay in the matter cannot be attributed to the petitioner. Under such circumstances, we are of the opinion petitioner has been able to make out a case for bail on the ground of delay in trial allowed.
grateful, Lordship.
Next.
My lord, I am for the petitioner. As per FIR, the child was missing at the time of the celebration of the birthday party of the son of the accused person. And only on the basis of the suspicion, the FIR has been lodged. De facto complainant and the accused persons are close friends. On that said party, both all including the de facto complainant and accused persons are drunk in condition.
My lord, the name of the petitioner is Pinky Bormon. There was a specific observation of Pinky Bormon that from the house of this person, this
Pinky Gupta.
Pinky Gupta, I stand correct. My lord, the male child of the de facto complainant was kidnapped. Now, Pinky has already made an agreement with an Romain Bagh that this girl will be sold, and she personated herself to be the mother.
As per CCTV footage, the accused
1,20,000
person
has
was
been
not
recovered from
seen.
his possession in the agreement.
And
Where is this?
Petitioner.
the accused person, including her newborn baby, was in custody. Is in custody 185 days.
Petitioner contends that she and her newborn child are in custody. She
Charge sheet has been
custody
submitted
for 185 days. She is no way involved in trafficking of children. She prays for bail. Learned lawyer for the state submit. The one child was trafficked or more than
One.
the child was trafficked from the residence of the petitioner. We have considered the materials on record, statements of witnesses and other attending circumstances show petitioner personated herself as the mother of the child who was trafficked. Full stop. This prima facie discloses involvement of the petitioner in a grave offense of child trafficking. Under such circumstances, we are not in view of the nature of the crime, we are not inclined to grant bail to the petitioner at this stage. Rejected.
Deeply.
Next.
Lordship, I am for the petitioner, Lordship. Allegation of section 341, 323, 325, 327. Lordship, allegation of section also.
All right. What is the injury?
Lordship, I am because 37, Lordship. Lordship, 5% have been granted.
How long you are in custody?
37 days.
Huh?
37 days.
37 days.
37 days, 5% have been granted anticipated bail, Your Lordship.
Petitioner contents. He is in custody for over a month. Co-accused have been granted pre-arrest bail. He prays for bail. And a lawyer for the state contents number of persons were injured. We have considered the materials on record. Whether the injuries are life-threatening or not, request to be assessed during trial. Materials including the injury reports. keep balancing the nature of accusation with the co-accused have been granted pre-arrest bail, balancing the nature of accusation with the period of detention suffered by the petitioner. We are inclined to grant bail. Next.
I am for the state.
My lord, case under section 6 of POCSO Act. Petitioner is in custody for 198 days.
Girl is aged about 10 years, not yet examined, charge has been framed.
We have considered the materials on record. Petitioner is involved in the penetrative sexual assault on a 10-year-old child. Vulnerable witnesses are yet to be examined in view of the gravity of the offense and the stage of the proceeding. We do not consider it prudent to enlarge the petitioner on bail at this stage. Next.
I am for the petitioner more than 263 days in custody. There are 4 accused persons out of petitioner. All of them are released on bail. 2 of them has been released by the learned additional district judge, Murshidabad, and 1 by the Honorable High Court. More than 263 days I am in custody, my lord.
We have considered petitioner contents, co-accused are on bail. He renews his. You are Firoja Khatun?
No, my lord. I am, my lord, Sabikunnahar Bibi. Firoja Khatun has been granted bail by your lordships.
Firoja has been granted bail.
My lord, why? This is the wife of the deceased.
And 2 of them has been granted bail by the learned court below.
Who emasculated you?
This person,
My lord, the 3 persons were, my lord, in similar footings, all of them. Except Mujibur, 3 of them are similar footings.
petitioner, her daughter, these 2 my lord, persons, my lord, were
All of them are similar footings except Mujibur Rahman. He is a conspirator as per FIR. And there is no direct evidence, my lord.
Has been rejected earlier.
Yes, yes.
In order
Earlier, my lord, in the month of October, my lord, 3 months ago. Then, my lord, other accused persons were on jail.
who has been granted bail? We have given Firoza on the ground of health.
And my lord, Bina Bibi has been granted bail by the learned court below. Mujibur Islam has been granted bail by the learned court below. Bina Bibi.
Bina Bibi on same footing, Mr. A.
Same footing, my lord. Same footing.
64 statement, my lord, then these 4, my lord, names are appearing, my lord.
Together.
Yes, my lord, can you see, my lord?
Petitioner contends that she is in custody for more than
263 days.
63 days. Co-accused have been granted bail. He renews his bail prayer. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Allegations are grave and involve a emasculation of the victim who ultimately succumbed to his injuries. However, co-accused are on bail and there is no progress in the matter since rejection of bail by this court. Full stop. Petitioner is a lady and there is no chance of absconding. Under such circumstances, we are inclined to grant bail. Allowed. 10,000 issued.
My lord, I am grateful, my lord. Highly obliged, my lord.
My lord, I am for the petition in this matter, my lord. I am in custody for about 2.5 years. 7 co-accused persons have been enlarged on bail by your lordship.
Petitioner is in custody for 2.5 years. When was your bail prayer last rejected?
But it was rejected about 1.5 years back.
All right. Petitioner is in custody for 2.5 years. He contends co-accused have been enlarged on bail on the ground of delay in trial. He prays for similar relief. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Though petitioner is in custody for a protracted period of time, there is little trial has not progressed.
Out of 45, only 3 has been examined.
Only 3 out of 45 prosecution witnesses have been examined. There is no possibility of trial concluding in near future. Co-accused are on bail. Under such circumstances, we are inclined to grant similar relief to the petitioner.
Grateful, my lord.
Next.
Deeply obliged. ACGM Shialda.
20. Wait, please. I am paying for the petitioner.
Time.
20 and 25 rising out of the same
My lord,
case.
20 and
no, not
25.
today. Only not today, my friend.
Not today.
Not today.
All right. How many days you are in custody?
Well, I am in
184.
custody for
Today, my lord.
196 days.
I am in custody for
I'm-
245.
96?
196.
196.
And out of 12 persons who are in custody, 10 have been granted bail. We two are in custody, my lord. And so far as Mike is
Only not. Only not today.
Tomorrow? No. Tomorrow. Not today. Next.
The 21, I'm for the petitioner.
Have a statement.
My lord, I'm in 302, my lord, I'm in custody for 3 years and 11 months. My lord, till date, my lord, not a single witness has been examined. My lord, in fact, my lord, in October 2022, your lordships directed the trial to be concluded within a year.
Yes, why?
Well,
There is
Not a single witness examined till
It's
date.
on the 31st of January 2024, my lord, for examination of the PW1.
Yes.
31st of January?
January 2024, my lord.
Why this was, there is delay in trial, you give a report.
My lord, as per my lord, going through the records, my lord, prior to that, my lord, we issue the summons, my lord. The witness is not turning up, my lord.
What is the evidence against them?
My lord, evidence is that, my lord, he, my lord, committed the murder. His, my lord, wife, and my lord, another one person, my lord.
You have said what is the evidence? You have just said the accusation.
My lord, section, my lord, page 11, 12, but directly, my lord, implicated the, my lord, the.
How did they implicate? Were they eyewitnesses to the murder?
No, my lord.
Then what is the
My lord,
materials against
fact is that, my lord, one, my lord, Ali Hassan, my lord, called the, my lord, the two lady to, my lord, getting the, my lord, the maintenance amount, my lord. Subsequently, my lord, they were missing, my lord. On the very next day, my lord, two body has been, my lord, found. And my lord, all the witness has been stated that these two persons, my lord, with Ali Hassan and the Mijanur, my lord, the husband of the, my lord, one of the deceased, my lord, committed murder.
How did they know they committed murder?
My lord, one, my lord, offending weapon, my lord, the knife.
Now to give us, this is very vague statements you are making. It's a circumstantial evidence case. So tell us what are
Only
the
the, my lord, knife has been recovered from the position of the Mijanur, my lord.
So knife is enough. Motive we understand.
Motive, my lord, the one of
Motive we understand. You made out a case for motive. They were estranged husbands. Now Ali Hassan had called these victims to take maintenance. Now Ali Hassan is not before us.
No, my lord.
This is Mijanu. Now, and from Mijanu you just recover a knife. Knife is sent for FSL examination.
My lord, sent for FSL, my lord.
What is the report of FSL?
My lord, FSL report is, my lord. Make it, my lord. Give me one day accommodation.
Give a report. Petitioner is in custody for more than 3 years. He contends there is slow progress in trial. He prays for bail. Learned lawyer for the state shall submit report disclosing the incriminating materials against the petitioner and the reasons for delay. Matter will appear 1 week hence.
I'm deeply. I'm deeply.
Next.
22, I am for the petitioner. No, 394, 397, I am in custody for 5 years, 9 months. If your lordship kindly
How many
comes to,
witnesses examined?
my lord, out of 25, my lord, since 24th of March, only 11. Thereafter, after your lordship's rulings, my lord, will kindly have a look into page 27, annexure P5. Now, right now, 21. Now, my lord, what actually happened?
Petitioner is in custody for more than 5
My lord,
years.
may I?
He contends, in spite of direction given by this court, trial has not concluded. He renews his bail prayer. Learned lawyer
Not
for
renews, my lord, my fresh application.
co-accused.
Co-accused observation is there.
He prays for bail. Learned lawyer for the state opposes the bail prayer.
My lord, kindly see the impugned order, my lord.
Page,
Within 6 months, it has been directed to complete. It was
my
not.
lord, impugned order.
My lord, page 28 is your lordship's observation.
Right. I have gone through the order sheets, find that the prosecution produced the witnesses for cross-examination by the defense on a number of occasions. But the defense chose not to cross-examine them and sought for adjournment, one after another. In such a situation, it cannot be.
Page 55 once, my lord.
Last page,
Witness was sick and his
impugned order.
medical report was submitted. Next date was.
Are you for the state?
Oh, I'm sorry.
State. Yes. What are you saying?
Impugned order, my lord, kindly see. Order dated 22/11/2023. My lord, the line starts with I have gone through the order sheets. My lord, middle portion, my lord. I have gone through the order sheets and find that
So you place the entire order sheet. Petitioner is in custody for more than 5 years. He prays for he contends there is delay in trial. He prays for bail. Learned lawyer for the petitioner shall submit shall file supplementary affidavit enclosing the order sheet.
But I have annexed all the orders. That's what I'm trying to point it out, madam. If your lordship kindly comes to page 38 onwards, the relevant portions are page 43, 45, 46 and 55.
Like inter order has not been annexed.
There was a direction to complete the trial within 6 months. It was not
Yes,
since
please.
24th of March. And on the last occasion, my lord was pleased to grant bail to the co-accused because his performance inside jail was not impressive. That's why your lordship was rejected in the bail application.
Well, it has been communicated, the order has been communicated on 15/6/2023, that is at page 42.
15/6. So it should be
15/6.
concluded by December.
My lord, that is there, my lord, my lord, kindly see page 46, my lord, the case has been adjourned due to resolution of local bar. Page
So
55, my
who
lord.
is responsible?
witness
Why
was
your prosecutor agreed to the resolution of the local bar?
My lord, and page 55.
Is not
my
a
lord,
public prosecutor a public
absolutely,
servant?
Absolutely. my lord.
Then
And on the page 55, my lord, witness was ill. That
page
is why
46
medical
is
report
very
was,
stalling.
and my lord, page
Witness was present, the presiding officer was on leave, the learned judge was busy with his own file. Page 46.
and page 45, my lord, PO only.
Both 45 and 46. And I don't have any criminal antecedents.
No, criminal antecedent is there, my lord. It appears from page 41.
And that is against the
No, that is against the petitioner, my lord.
right.
Page 41. He was arrested from Bhagalpur.
No.
No, we have the Supreme Court judgment with us. বছরের মধ্যে 6 বছর
Petitioner is in custody for 5 years and 9 months. He contends that there has been inordinate delay in trial in spite of direction given by this court in CRM DB 1082 of 2023 to conclude trial within 6 months. Trial has not concluded. He prays for bail. Learned lawyer for the state opposes the bail prayer. He contends that defense had sought adjournment for cross-examination of witnesses. 20 in spite of non-cooperation on the part of defense, 21 witnesses have already been examined. We have considered the materials on record. Petitioner is in custody for more than 5 years, for 5 years, 9 months. Offenses, even if proved, would not attract mandatory life imprisonment. With regard to the observation that defense had sought adjournment of cross-examination of witnesses on a number of occasions, we have gone through the order sheets annexed to the petition. We note on certain occasions, prosecution witnesses were absent and even if present could not be examined due to absence of the presiding officer. These defense cannot be held responsible for such delay. With regard on other occasions, namely on other occasions, namely, 2/9/2023, 4/9/2023, 5/9/2023, 6/9/2023
11.
and 11/9/2023. Defense had cross-examined the witnesses on the very day they were produced. In view of the aforesaid circumstances, we are of the opinion the progress in trial had not been impeded by the defense so as to deny the petitioner right to bail on the ground of delay in trial. Accordingly, we are inclined to enlarge the petitioner on bail subject to conditions. 10,002 sureties petitioner while on bail shall report to officer in charge, shall remain within the district of South 24 Parganas, provide the address where he shall reside to the investigating agency and the court below, and report to officer in charge, Westport Police Station once in a week. তুমি ওইখান থেকে অর্ডার শিট থেকে পেয়ে যাবে নেক্সট impeded by Hon'ble. Yes, next one.
Now, this is the third application by the petitioner. He is in custody for 345 days. Now, the case has been committed to the court of session, but till date, the charge has not been taken. This is the only part that I can draw your loss of attention. Earlier, you
Yes, Mr. A. Nondi,
May I just bring the status report?
bring the status report.
Otherwise, 164, he has been directly named.
Yeah, no, the injured witness has named him. We are rejected on merits in July. What is argued by Mr. Basu
My lord,
is that there is no urgency on your part. You have gone off to sleep. So show us that there is urgency and adequate steps have been taken. Petitioner renews his prayer for bail. He submits petitioner submits there is no progress in matter since rejection of bail by this court. He renews his bail prayer. Learned lawyer for state shall submit report with regard to status of the proceeding on the adjourned date allowed 2 weeks.
কত তারিখ হলো? দাদা?
Yes, next matter.
My lord, 128 days in custody. I am a Pradhan. The allegation.
Neki Ahmed, Mr. Appearing for this statement.
1 second.
I gather he has not come to court today, my lord.
Negi has not come to court.
No, my lord.
You are murdered. Then
More, I think
what Pradhan? It's
no, my only thing against me.
409. Pradhan General of
Yeah, 409. No, this is a case.
You have gone beyond 409.
Punishment same, my lord. Well, let him come tomorrow, my lord. Let Mr. Neki Ahmed come.
Not today. Next.
27, 20, we have prayed
Oh,
for
25 we have said tomorrow.
May it please the Lordship, I am for the petition. My lord, case has been registered under section 4 and 5 of the Explosive Substances Act, along with my lord 131 of the Motor Vehicles Act. Now, these two petitioners my lord, were intercepted by the police. My lord, orange-colored stony powder was recovered. So far as 23 kilos are
How
concerned.
long you are in custody?
1 year, my lord. I am in custody, my lord. He is
There is a
63
direct
years old.
recovery of 23.150 kgs of arsenic
Petitioner is
sulfide,
in
my lord.
custody for more than a year. He
My lord,
submits there is
Trial
no
had started. First,
progress in the there is slow progress in trial. He prays for bail. Learned lawyer for the state contends
Well,
that a large volume of explosives of ammunition.
and there is criminal antecedent of
All
this,
right, we are asking what is recovered.
but arsenic sulfide.
Arsenic or
Arsenic.
ammonium sulfide
Arsenic sulfide. That is
Arsenic
used for
sulfide.
explosive. Yes.
or ammonium sulfide.
No, my lord. This is
Just find out.
this is arsenic sulfide, my lord.
Arsenic. Large volume of arsenic sulfide that is explosive substance was recovered from its possession. Trial is in progress. We have considered the materials on record. Allegations against the petitioner is serious, but he has suffered incarceration for more than a year. Prosecution proposes to examine how many witnesses?
7.
Seven witnesses there, one witnesses, his cross is there on 29th of January.
Seven witnesses, there is no possibility of trial concluding in near future. Under such circumstances, we are inclined to grant bail. Allow 10,000.
I'm grateful. I'm deeply obliged.
Kotakar lok to this. Birbhum. Birbhum, you are moving around with explosive in Kolkata. Yes, next matter.
My lord, I intend to not press the application. My lord, I've been instructed that he's been suffering from some mental disorder. They have filed few petitions before the lower court. So, my lord,
Not pressed.
my lord.
Next.
My lord, I'm for the petitioner, my lord. My lord, I'm not pressed this application, my lord.
Why?
By the instruction of my client, my lord.
The same putting another person is rejected.
All right.
One person granted bail because he was not present, but this petition very much involved in the murder case.
My lord, 376, 500.
Huh? 376.
376, 500.
Murder case you are saying.
28. I don't know.
What bar councillor?
28.
Huh? Next election you will not win. You are changing rape to murder. Well, our blessing will not help you. Your brothers and sisters' blessing is necessary. Not praised. Mr. Posum Datta, when is bar council election?
Not next year, possibly.
24 this year?
Next year. We'll actually extend it for 6 months, one year.
Next.
My lord, not pressing this application.
What?
Praying.
Oh, not pressing the application.
You see there, these applications, this application, my lord, the another co-accused application was rejected by this honorable bench, a similar footing. And another as
Bail prayer of co-accused has been turned down.
that is there.
Under such circumstances, petitioner chooses not to press the bail application. Application is dismissed as not pressed.
My lord, I am for the petition. My lord, this is the case under section 392, 397, 302, 34 of the Indian Penal Code, 25, 27 arms.
Yes.
Incident is, my lord, 4 persons, namely, my lord, Vishal, Juvaraj, Raju, and Hero, hired one vehicles, and they from Bardwan, they want to reach Calcutta. In the meantime, on the road, my lord, they snatched the vehicle. Driver protested, and my lord, admittedly, my lord, Vishal fired the driver and left with the vehicles. My lord, then police came. Police arrested Vishal from the spot, and ammunition was recovered. But so far, other accused person, it is not clear. I am belonging that other person. I am in custody 381.
But you were there with Vishal.
But it is statement of the Vishal. There is no eyewitness. Case based on the circumstantial evidence.
Not circumstantial, Lord. If your lordship kindly see the CDS. He called the Amarjit Singh. Well, he resides in Bihar. Called Amarjit 74 times, Lord, he called. Lordship kindly, 74 times. Mobile number from the period 29 November to 19th February. Date of incident.
Who is Amarjit Singh? The victim?
No, Paramjit Singh. Paramjit Singh, not victim.
Who is Paramjit Singh?
Accused. He also from the Bihar.
Co-accused, so what?
No. He hired the Millard. They hired the Millard. The killer.
All right. CDRs. In addition to that,
Millard on his during the PC, Millard on his leading statement, Millard 5 guns and Millard the ammunitions were seized.
Very good. All right. Take down.
Millard, kindly see Millard 4 persons all from the Bihar, and they Millard assembled in Durgapur. Thereafter, Millard hired this Scorpio.
Senior government advocate.
And all are in custody.
If these cases are so serious, you need to investigate and collect better evidence.
No, charge sheet has been filed, supplementary charge sheet filed.
We can assure you with the charge sheet, you won't be able to convict him for murder. You can convict him for possession of illegal arms, but not murder.
No, Madam Lordship, kindly see this CDS. Kindly see.
We have
kindly see the CDS. 164 of the Sun. Lordship, kindly consider them as CDS. All Paramjit and
understood. CDRs don't impress us. Tell us, in addition to CDR, what is there? What is the statement of the son? Does he
Son,
implicate
164
them?
টা দাও, 164 টা দাও। কত কথায় আছে?
That I have annexed, my lord. That is in my
এটা
application,
দিনতে যত।
page number.
Any stolen article was recovered from them?
No, not stolen article, but arms and ammunitions. Leading statement. And what the
Commissioner is in custody
came
for
to
314 days.
314 days. He submits that there is no direct evidence connecting him with the murder. He prays for bail. Learned senior government advocate. Senior government advocate.
as your lordship may give the ornaments, whatever it your lordship thinks.
Now additional public prosecutor.
No.
Senior government advocate
Hmm.
opposes the bail prayer. He submits petition
So all the
and entered into a conspiracy with co-accused CDRs of CDRs
came to
collected
Bardhaman and
during
Pandua every
investigation show telephonic conversation between petitioner and co-accused. Victim
came to
was
Bardhaman and Pandua.
abducted.
Thereafter returned back.
Victim was abducted and murdered and shot at.
Gunshot.
Firearms have been recovered on the leading statement of the petition. We have considered the materials on record. CDRs collected during investigation perceived. We have considered the materials on record. There is no direct evidence to show petitioner was present at the spot. Full stop. To rely at the spot. Statements of witnesses also at the spot. Full stop. No FSL report is placed on record to show that the recovered firearms were used to murder the victim.
The FSL report is there.
Is it matching with the bullet, etc., collected at the place of occurrence or from the body of the witnesses?
FSL report, kindly see the FSL report.
We have asked you one thing. It does not match. FSL report says in working condition. Right. We're in this backdrop, prosecution relies only on the CDRs collected during investigation, which shows telephonic conversation between petitioner and co-accused. Contents of the said conversation are not available. In light of the aforesaid, we are of the opinion. We are in view of the scanty materials on record in support of the allegation of conspiracy. We are of the opinion further detention of the petitioner is not necessary and he may be released on bail subject to conditions. Petitioner, while on bail, shall remain within the district of Hubli, provide the address where he shall reside and meet officer in charge Pandua police station once in a week.
I'm extremely grateful.
Next.
May it please your lordship. Lordship 498A, 307, 406, 34. Husband before your lordship. This is second marriage for both husband and wife.
What happened to first wife? Murdered.
No, first wife died.
And second wife attempted to murder.
Natural.
Natural.
No, first wife died of
Natural death.
Natural death.
And this is attempted unnatural death.
No, lordship.
And
Second marriage for both of them.
but the wife lodged the complaint.
What is the nature of injury?
65
Some
days.
poisonous substance, according to her, was mixed with the food. Now, kindly see page 16. It is said that it is due to drug overdose.
Lordship, she
that
is addicted to
she was
penicillin.
Taking 20 tablets.
Yes.
Then how can it be administered? Petitioner submits that the victim lady had herself ingested sleeping pills. Allegation of administration of poison is out and out false. He prays for bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record, including the medical report. His notings in the medical papers show self-ingestion of pills by the victim, full stop. Ingestion of victims pills by the victim. Allegation of attempt to murder requires to be assessed in the light of the aforesaid materials on record. There is no chance of abscondence. Accordingly, we are inclined to grant bail.
Mana investigation is pending.
Next.
Satisfaction. Right.
Yes, Shotodrul ID.
This is the POXO case, this is the affidavit of service. The petitioner is in custody for 1 year and 16 days. Next date is fixed on 8th of January 2024 for the consideration of charge that is appearing from the order.
Petitioner is in custody for more than a year. He prays for bail. He submits he has been falsely implicated. He prays for bail. And a lawyer for the state opposes the bail prayer. We have considered materials on record, including the statement of the minor. Minor stated that
There are contradictory statements.
Kidnapped and subjected to, and had been she had been kidnapped and raped by the petitioner. Suppose she is yet to be examined in court. Under such, in view of the nature of accusation and the stage of the proceeding, we are not inclined to grant bail at this stage. Trial court is requested to consider the issue of framing of charge within 1 month from the next date fixed before the said court, and in the event charge is framed, to take the proceeding to and to examine the victim at the earliest. Next. $33.
For the statement.
Yes. What is there?
For the case out of 11, 6 has been examined.
How long is in custody? Well, others are on bail.
Other 3 are on bail. He is standing on side.
He's not there. Maybe granted bail by not today. No, not today. Tomorrow is not there. We'll dismiss for default. Next matter. Yes, what is this matter?
Lord 35, I am appearing for the High Court administration.
34 and appearing for the
Union is a party, my lord, but merely for the sake of form, my lord, in this matter.
Lord 35, this proceeding commenced in terms of an order dated 16 September 2020, passed by the Honorable Supreme Court of India in an Article 32 writ petition.
Correct. Can you place before us the latest orders passed by the Supreme Court in this matter?
My lord, that is evident in item number 34. A separate proceeding was directed to be instituted.
So what case was registered in the name of Henry designated courts for appeals and everything.
After that, the Supreme Court has passed further orders
9th November
in this matter. After that, the Supreme Court has passed further orders in this matter.
In Oshini Upadhyay.
Can you make a compilation and
Yes.
those orders?
Yes.
Learned Counsel for High Court Administration is requested to make a compilation of all orders passed pertaining to trials passed by the Honorable Supreme Court in Oshini Upadhyay versus
Lordship can mention the writ petition civil number 699/2060.
in matters pertaining to trials. With regard to trials pertaining to MPs and MLAs on the adjourned date. When do we keep it?
10 days, my lord.
Adjourned 2 weeks.
In fact, my lord, the last order, my lord, dated 9th of November 2023.
We want a compilation. Make a compilation, place it before us. Because after that, I think there were certain directions, further directions given by the others.
9th November order last ছিল 23 November order হাইকোর্টের অর্ডারতে ইন্ডিকেটেড
Compilation of Shuni judgment cases on
My lord, there is another aspect. We were directed to indicate before the Honorable Court as to
what are the budgetary allocations which are not being given by the judicial department. We have used an affidavit. There was a response by the state government. We took an exception. We circulated that exception, which is on record. My lord, in the meantime, the Advocate General and Public Prosecutor has changed.
When should we keep it?
Let us fix it on 16.
Then we carry the word auditor. Learned Counsel for High Court Administration submits budgetary allocation for expeditious trial of MPs and MLAs have not been made.
Yes.
Learned Counsel for State seeks adjournment to clarify the position. Seeks adjournment to take instructions in the matter. 2 weeks. In the meantime, Mr. Mitra, you prepare, we are not recording that, you prepare a compilation of the directions in Ocean.
Passed by the Supreme Court.
Right, subsequent directions. There have been further directions, maybe relaxing some of the earlier observations.
Gotcha.
All right. Yes. Yes, Miss. This matter, I do not, it's very old matter, right?
It's a very old
I
matter.
think I may have appeared in this case.
Lordships had actually granted special leave by bench presided by your lordships. And therefore, this is just a formal filing of the appeal, lordship. Therefore, this is just a procedure. There's nothing, I mean,
but
because in July 2023, your lordship said
this, when is this prosecution?
Prosecution
relates to?
Prosecution is a very old.
97. Let it be placed before another, released on personal ground.
Lordship, actually, the special leave was granted by your lordships.
Let us be.
Lordships, I mean,
I vaguely remember may have appeared.
Your lordship sitting with Justice Ajay Kumar Gupta granted special leave. Anyway, I don't want to embarrass you. Anyway, deeply.
Chapter has already filed an appeal that has been admitted.
All right. Leave.
My lord,
You
I'm-
require leave. All right. Appeal admitted. Appeal shall be heard along with CRA.
My lord, I am in item number 38. This appeal is on behalf of the complainant. This was admitted on 1st of August.
That's what we are saying.
Yes, my lord, but after that I have filed an application under section 437A, praying for a direction upon the accused persons to furnish bail bonds.
We are giving a direction. Appeal is admitted, issue usual notices, call for records. Appeal shall be heard in pending hearing of the appeal. Adota CRA, it have heard learned counsel for the appellant victim. Pending hearing of the appeal, appellants shall, the respondents shall be, shall appear pending hearing within 15 days from, we have considered materials on record learned counsels. We direct the appellant, we direct the appellants to surrender, appear before the trial court within a fortnight from, within 30 days from date. Notice has been issued.
My lord, I have served, but this is the service is complete with respect to respondent number 3411, 23411 and 12.
Can't have apology. Service is not complete. Fresh notice be issued upon the respondents. Matter will appear once.
My lord, grateful.
Huh? 4 weeks.
Great.
Action check.
What are these?
My lord, one is against the same order of acquittal, my lord. As a victim, we have preferred an appeal. My appeal has been admitted already.
All right.
My lord, I understand the state of
also. Usual notices, call for records. Appeal GA shall be heard with CRA DB's words.
My lord. Lords. এই যে অর্ডারশিপ লিস্টে আছে দুটো ম্যাটারই লিস্টে আছে ট্যাগড ম্যাটার
Yes, Miss A.
I'm deeply obliged.
41. Oh, Mr. Sengupta, give notice.
Acquittal
Notice. Cran 1.
delay of 27 days.
Give notice. Notice application for condonation. No, sir. Cran 1 order karo, huh? Application be served upon private respondents personally as well as registered speed post with acknowledgement due. After service be filed on the agenda, adjourned 4 weeks. Next, same order. 41, 42, same order, Mr. Sengupta.
4 weeks.
43, my lord, there is a delay, my lord.
Same order.
Yes.
Nobody appears. 6 weeks. 6 weeks. Adjourn 6 weeks. Miss A, please see the state appeals, whoever is appearing intimate. We are adjourning today.
টা তো সেম অর্ডার বল 43 টা তো সেম অর্ডার আমি হাতিয়ার করলাম
43 is same order. 44, nobody is appearing. Who is appearing in 44? So adjourn for 6 weeks. Adjourn 6 weeks. Please inform Mr. Gupta. He is not there. His senior is also Ranubida. Yes, next matter. Application.
Lordship, I am 25 days delays, Your Lordship.
Which one?
For item number 46.
What is this?
Your Lordship, I have filed an application for modification of the order.
What order?
For there was some condition, Your Lordship, where my passport has been impounded for releasing of the passport. Cran 2, Your Lordship. Cran 2 for modification of the order for releasing of my passport. But that application, at the time of service of that application, I mentioned in my service letter that the matter will appear on 18th.
All right. Yes.
But
what do you say?
But the matter was listed on 17th, Your Lordship, and as I am not appeared, the matter was dismissed for default. There and from the 19th, the puja vacation has started, Your Lordship.
Once again. What are you saying?
Well, I need to take a further report, my lord.
Take a further report.
My lord.
So where do you want to go?
Your Lordship, recently, for my job purpose, I want to go abroad, Your Lordship. And another thing that recently I got married, and for my honeymoon, I want to go.
You want to take a choice, honeymoon or work?
Yeah, work. Work is
You definitely won't go to Central African Republic for honeymoon.
No, no.
Would you?
That for my job work. Yes,
For
so that
your
I validate
work.
all my
For your
documents.
work. Now,
For my work.
if you go to work, what is the how do we ensure that you will come back? Any relation of yours
Yes,
who stays in India?
Your Lordship, my parents are there in Nasik. I'm permanent resident of there. I have annexed all the documents. My sister, my
We
mother are
want
there.
one of your relations to furnish a bail bond
Your Lordship. Your Lordship.
of some amount, adequate amount.
Your Lordship. As your Lordship may pleases.
All right.
Your Lordship.
Who is there? Can you give a supplementary affidavit saying that your father or mother is willing to, or your brother is willing to furnish a bail bond, and that brother will not leave the country, does not have a passport? Because if, let us say, you do not come, then we can, the court can proceed against one of your relations, right? So we want that undertaking, right? Please, can you give us a clarity on that? Who is available in your family to do that?
My mother, I'm living with my mother at
Right.
present.
Does your mother have a passport? Does your mother have a, find out? We are keeping in next
I
week,
have
all
to take
right?
instructions, Your Lordship.
Instructions.
Your Lordship, kindly fix the matter, or I'm led by Mr. Tariq Asimuddin. He went to Makkah to perform Umrah. He's kindly fix the matter after 15th of this month, Your Lordship.
All right. On the prayer of the petitioner, we have considered the applications with Section 5 and restoration is?
Yes. CRAN 3 and CRAN 3 Section 5 application, Your Lordship, and CRAN 4 my
And 3, having considered the averment, so and so, delay in filing application for restoration. For recall of order dated 17/10/2023 is allowed. We have also next CRAN 2. We have considered the averments in so and so. Petitioner was unable to appear before the court due to circumstances beyond his control. Hence, order dated 17/10/2023 dismissing the application being CRAN so and so. CRAN 4, CRAN 2 of 2023 is allowed. The application is restored to its filer number. Place the matter for hearing 3 weeks hence. State shall submit report by the adjourned.
I'm ready.
That person will make an input from the state petitioner. If she has a passport, that passport will
Yes. But I was granted anticipatory bail. My condition in the anticipatory bail was also relaxed. But thereafter, the de facto complainant came up with an application for cancellation of my bail. Now, in that, certain conditions were imposed. Now, for the last 1.5 years, there is no complaint from her. The condition was that I shall not enter into the jurisdiction of Titagore police station and I shall meet the investigating officer. But I have been all along
Has the
complying
victim
with the
been
condition.
examined? Why not? Let the victim be examined first.
My lord, may I obtain a report, my lord?
See, the victim is here.
Oh.
You obtain a report as to why you have not examined the victim. What is the stage of the proceeding?
But 8th of September was the date fixed for evidence, but nothing happened on that.
We petitioner pressed for relaxation of condition of bail. Conditions were imposed upon the petitioner on the prayer of the victim complainant. She has not yet been examined. Trial court is requested to examine the victim complainant at the earliest. Matter will appear 8 weeks hence.
Grateful, grateful, grateful.
Grateful, man.
And for the petitioner, lordship.
For the opposite party,
The affidavit in reply.
my lord, opposition has already filed, your lordship. Just received the reply.
What is the stage of the proceeding?
Trial is going on, Lordship.
Then petitioner affidavit in opposition is placed on record. Reply you are filing.
Reply, no, my lord. Opposition I'm filing. They are giving the reply.
Acha, affidavit in opposition is placed on record.
I am filing the reply.
Oh, opposition and reply are placed on record. State shall submit. There is no allegation of misuse of liberty.
No, there are allegations, Lordship. The petitioner, they are threatening the witnesses, Lordship. And another case are filed on Lordship. That is in reply page number, paragraph number 4. When the
Have they
wife of-
violated any condition? Have they entered Noyati?
Yes, they have violated the condition.
Where is that?
Reply, Lordship, kindly comes to page, paragraph number 4 and 5.
Who is
And
appealing
the
for
cases.
your state?
I am for the state, Lordship. Actually, they are notorious criminals, Lordship.
All right.
Several criminal antecedents are there. There was a direction not to enter the jurisdiction. They have violated that. And when the
You give a response to paragraph 4.
Yes, your lordship, I will.
Joined to the averments made in paragraph 4 of the affidavit in reply be placed on the adjourned date. Matter will appear 4 weeks hence.
Extremely grateful.
Otherwise, we'll cancel the bail.
My
There
lord,
is
we will.
allegation of misuse of liberty.
Omnibus allegation, your lordship.
No, sir, not omnibus. And Miss Shatra, please produce the case diary in that case.
case diary.
Oh. In the case relating to abuse of liberty. Yes, next matter.
49 to 56, my lord, all analogous matters. Same point is involved here, my lord. My lord, in section 216, subclause 3(6) of the, my lord, the Companies Act, whether the twin condition has been fulfilled while granting bail or not. This is the only point before your lordship. Your lordship knows that the condition number 1 is, my lord, the public prosecutor has to be heard. At second, the learned judge has to come to a conclusion, satisfaction that they are not guilty of an offense. But without recording that, my lord, the learned magistrate on the first day, my lord, granted bail.
We were made to understand that they'll give affidavit in reply.
My lord,
They've
my lord,
got time.
my lord, no, my lord, we never prayed
But
for
you
time. My lord, they have
One time we will give you time.
no, my lord, they have given opposition only the factual aspect. We are not on the factual aspect. We are on the, my lord, propriety of the order.
We have cooperated.
And we have prepared, my
The
lord.
actual aspect, Mr. Majumdar, will also have an impact on the propriety.
Yes, my lord, we have prepared a note. My lord, in each and every matter, one note has been prepared for this court, my lord, showing the involvement of the accused persons.
Could we be given a copy of that?
Huh? Devo?
Please give us a copy of that. We know how we will take.
My lord, falsification of the, my lord, the balance sheet and the shareholding to justify the illegal money transaction. This is the crux of the matter, my lord. My lord, we have prepared, my lord, one note in each matter, my lord. All are chit fund companies.
So we'll fix it for hearing.
Yes, as your lordship, please.
You circulate the notes to.
Yes. My lord, sir, I am handing over, my lord, your lordship's copy first. My lord, we shall hand over their copy also.
On the prayer of the parties, matter is adjourned. When?
As your lordship, please.
2 weeks, 3 weeks from now.
3 weeks hence. Please indicate to us whether 216(7) will apply.
Yes.
And if it applies, then we have to set aside the order. If you can indicate that it does not apply, then
the allegation under section 447 itself. And so far as Mr. Ganguly's matter is concerned, 448, same punishment as 447. So, my lord, this statutory bar will apply in that matter also.
Right. We try to satisfy your lordship that it does not apply to that extent. There was an amendment prior to into 212(6), which contained 447 and 448. In the subsequent one, it excludes 447. Well, that
so
we have
448 remains.
448 remains, but so far as we are concerned, we have only been prosecuted under 447.
That is yours, client. Others?
448. 440. Sorry, 448. It was, I'm sorry.
In your case, it is 447.
In their case, 447.
Others are only 447. So
447.
If the amendment, Mr. Majumdar, is.
I shall look into it and satisfy your lordship.
That is why we are saying That is,
For I am concerned, my lord, I am a lady, I am exempted.
Yeah,
That provision.
exactly.
So that provision will.
But what about the recent decision of the Supreme Court that exemption of lady under section 45 of the PMLA Act will not be a carte blanche? Justice, I think Bose and Justice Trivedi's judge.
But here, madam, there is a recent order passed.
We will examine that, but please also address us on that judgment. Right? 4 weeks, even. Give us a date, we'll keep it in.
Yes, well, can you fix a date?
Any day.
On the. That's
2 yards, cross. Tirisha. Tuesday.
Well, 31,
Mhm.
30th of January is.
30th of January, it's a Tuesday.
30th of January we keep?
Yes.
Yes, ma'am.
30th of January. One by one we will.
Yes.
And in the meantime, they will circulate this.
Note
This copy will serve. এটা করে দাও সবাই যার যার আছে করে।
Fifty-seven. 56. 56 of each. 58. 57.
With 58.
No.
Yes, medical report we want.
My lord, medical report, what happened, my lord, they have, the accused on behalf of the Matapo, my lord, they have submitted before the court below that 7 tests are still remaining. Therefore,
All
the
right.
court below directed, my lord, to appear him on 21st December. But that day, my lord, whether he has appeared or not, my lord,
Mr. Borden seeks time to take instructions in the matter. Matter will appear 6 weeks hence.
get to.
Next. Nobody appears for the petitioner state.
Not in form, my lord, I need some time.
Ms. Mitro appears on behalf of the petitioner, seeks time. She seeks time to submit report. Matter will appear 6 weeks hence.
Sixty-one. Well, I am for the petitioner, cancellation of bail. Other 2 accused bail was cancelled by your lordship. My lord, last occasion, your lordship directed to file another report.
According to report,
Report is very vague. There is some statement saying that he entered and threatened. But he has a rented house outside.
Yes.
My lord,
Communicated to the.
What is the stage of the
evidence is going on.
How many witnesses have
Only 3 witnesses.
My lord, the next date is on, next date is on, my lord, 22nd of January 2024, lordship.
petitioner is in
my instruction,
further report with regard to the allegation of misuse of liberty is placed on record. Report states that Petitioner used to enter Mollarpur, Yarpur, Mollapara, avoiding police surveillance. Full stop. Proceedings under 107 CRPC has been initiated against him. In petition, opposite party is given liberty to respond to the said report. We are informed trial is in progress. We direct the trial court to examine the prosecution witnesses promptly. In the event they feel threatened, necessary police protection and assistance shall be given to them. Matter will appear 4 weeks since. Status of the proceeding we filed. Regard to status of proceeding we filed.
I am for the petitioner. Earlier occasion on 22nd of September, your lordship called for a report and submit the evidence of the victim. That case, my lord, in a trafficking, opposite party number 2 granted bail within 26 days. And next matter, my lord, same. The opposite party number 2 granted bail within 7 days and 11 days. This is the copy of the. Out of 21 witnesses, only victim witness examined.
Victim has been examined.
My lord. That is the. That is the. Kindly, that is the.
All right. Petitioner contends that petitioner challenges order granting bail to opposite party number 2 in an offense of sex trafficking.
My lord.
He contends court had not considered the gravity of the offense. He prays for cancellation of bail. State, in light of our earlier order, in terms of our earlier order, state has submitted a report with regard to status of proceeding. From the report, we have heard the learned counsels for the parties. We have also perused the report submitted by the state. The report states that the deposition of the victim has already is complete. Full stop. Necessity for detention, pre-trial detention is for the purposes of investigation and ensuring protection of witnesses, protection of vulnerable witnesses. Victim, that is the vulnerable witness, has already been examined. Full stop. In view of the approach, though we are of the opinion the order granting bail does not bear. Though we are of the opinion that the order granting bail is not happily worded, in light of the progress in the matter, particularly the progress in the matter, that is, the victim girl having been already examined, we find no reason to cancel the bail of the opposite party. Full stop. We request the trial court to conclude the trial as expeditiously as possible, preferably within 1 year from the next date fixed for recording evidence. Opposite party shall render cooperation. All parties, including the opposite party accused, shall cooperate with the trial court in the matter. In the event they fail to do so, it shall be open to the petitioner to renew his prayer for cancellation of bail.
Great.
Item 63 also the same
matter, same matter.
Same order,
granted
same
bail for
order.
7 days.
62, 63. We would have considered.
I'm ready.
Next, CBI.
Sure, I am seeking a week's accommodation.
2025.
No, just a week's accommodation. Next
2025 matter.
the affidavit of service is not like just a week's accommodation.
So both matters.
Lordship, in next matter, Mr. Trivedi is
all right. On the prayer of learned counsel for CBI, matter is adjourned 2 weeks. 65.
65, I am paying only not today.
Same order, both. 2 weeks. Next.
66, my lord, I appear for the petitioner, my lord, cancellation of bail. My lord, your lordship was pleased to enlarge the petitioner on bail on 24th of January 2023. Thereafter, my lord, regularly extorting money by putting him under dire consequences from his father, and my lord started pelting stones in the month of March.
Has the opposite party appeared?
My lord, affidavit of service is ready, my lord.
Affidavit of service file, nobody appears for service complete.
Service, my lord.
Huh? Let us see. Otherwise, fresh service. Fresh notice be affidavit of service filed. Nobody appears for opposite party number 2. Fresh notice be issued upon opposite party number 2 with registered speed post. File affidavit of matter will appear 8 weeks hence. Next.
I am for the petitioner.
My lord, I'm for the opposite party number 2. My lord, there was another connected matter, my lord, which was appearing with this matter, where the opposite party number 2 had filed for a cancellation, my lord, with regard to SC/ST Act. My lord, that is due to appear on the 14th of January, my lord.
All right.
So, these two matters
List along with so
Yes, sir.
The 14th, the date was on 14th December. Subsequently, it was not appear. I have the order.
But it was list along with so and so.
Because last occasion in this matter was adjourned as because your lordship was directed to the state to submit a report regarding truthfulness of 2 general diaries which was lost at the instance of.
Acha. Full stop. Listed aage bolo. Report is placed. Report on behalf of the state with regard to the credibility of the allegations of misuse of liberty is placed on record. Report states that the allegation of threat held out by opposite party number 2 was inquired into, and a separate criminal case being Kharagpur GRPS NCR 290/23 dated 9/3/2023 under section 506 IPC has been registered. State shall produce the case diary of the case. Response to the copy be handed over to the opposite party number 2. Response to the report be filed on the adjourned date. Matter will appear 4 weeks hence along with Swan.
That is
Report of the jury
the order.
before Kotwali PS.
That is the order.
Acha.
Just the tag.
Inquired into and 2 criminal cases being NCR so and so and 138 of 22/2/2023 under 506. Report will be registered. Case diaries of those cases we also produce. What is the utterance? 506 you need to place on record what were the utterances. Otherwise, just saying threat with dire consequences will not do.
There's another scheduled case, my lord, where we have preferred for cancellation, my lord, SC/ST Act, where we were not.
Same thing. Utterances in the scheduled cast case. Otherwise, scheduled cast case does not stand.
Very good. Deep
that, my lord, I will address on that. On that.
Deep
Great.
Well, I am for the petitioner, man.
Yes.
This is the opposition, my lord. I am filing it to the Lordship's court.
Yes, Mr. Why bail will be cancelled?
My lord, I have taken point para number 7, my lord.
Para number 7. 13. All right. Yes. Every opposition is filed. Then a lawyer for the petitioner contends that opposite party number 2, after being released on bail, had threatened the petitioner and his associates. General diary had been lost. Learned lawyer for the opposite party number 2 denies and disputes the allegations. We have considered the materials on record.
But I will file reply, my lord.
Reply or হবে না? We have examined the-
my lord, client had submitted another letter of complaint to the commissioner of police.
So that no further letter of complaint, that's why today finished. All right. Give us the letter of complaint.
My lord, kindly give us chance to file the
No,
reply.
we're looking into that. Give us that. We have considered the learned lawyer for the petitioner contents.
And also, my lord, after the bail, my lord, one incident occurred, my lord, an FIR was lodged against the Joseph.
So allegation is against police officer.
My lord, kindly see the FIR. My lord, kindly see the FIR, my lord,
What FIR?
against the persons, my lord, who were granted bail, my lord.
Who? Who are granted bail? Noshad, Istaq, Arshad. This is 17-4. When was the bail granted?
So it's 6th of January and 6th of December. Page 11 and 30.
Two bail applications cannot be challenged in one petition. Separate petitions are necessary. It is alleged that there is a separate subsequent case was registered against your client.
But we have no knowledge about that.
So you let him file reply.
As your lordship.
Affidavit of reply enclose these facts so that they can respond.
Yes.
Affidavit of reply be placed on record. Filed within 4 weeks. Matter will appear 6 weeks.
My lord, kindly fix the date.
6 weeks. Find out from our officer. He'll give you the date.
He will serve a copy to me also.
Everyone.
Opposition to
You also produce the case that let him place on record the subsequent case.
Yes.
He alleges that in April there was another case where they went and
that copy has to be handed over to us because a copy has been handed.
Copy will be handed over. What we are saying to Mr. Shuri is if he gets the copy, let him get the case diary of that case over.
Yes, yes. The copy টা দিন
Case number
Extra date.
আমাদের তো রিপ্লাই দিতে হবে
Oh, opposition you have not given to them.
No, my lord. Opposition. Well, I will.
We have filed opposition. Now, let this.
I will let him file a reply. He'll enclose all these documents in the reply. He's just handed it over to us.
Yes.
We wanted to see the additional documents. We find there is some substance in the additional documents. So let him file the reply. Next. Yes. Who is there? Nobody appears. 8 weeks. Next.
70, my lord, I beg to appear on behalf of opposite party number 2 and 3. My lord, we are enjoying bail.
You filed your affidavit?
Yes, ma'am.
Affidavit in opposition we filed. 6 weeks. Reply 2 weeks. Matter will appear 8 weeks since.
I'm grateful, my lord.
ডেটটা কবে